couple of quick words about trade secrets. Trade secrets are not governed by any type of registration that you apply for at the intellectual property offices throughout the world. It's governed by common law, and basically as long as the secret is maintained, you will have protection on that secret, whatever it may pertain to. Any information that is or used in trade or business could be considered a trade secret. Your customer lists, that could be a trade secret. Again, it's potentially any undisclosed and potentially patentable inventions, as long as you keep them secret. With a patent, once it's granted, you have 20 years of protection from the date that you filed that patent application. It can be expensive. You've probably heard that, and it's true. It can range from $6,000 on the low end to maybe $15,000 on the high end, depending, and that's for each jurisdiction that you file a patent application in, depending on the complexity of the technology. The area that I work in biotechnology, can be very, very difficult to draft an application because a lot of data has to be put in to support what you're trying to claim. So those applications tend to get a little bit more expensive than your normal widget type of application. And you can see down here, patents cover digital and analog hardware designs, firmware, some types of software. This is an area of great debate in most jurisdictions, whether the Patent Act actually does cover software. And Canada right now is actively trying to look to see if our act covers software, as well as the US, and more traditional things such as drugs. Why use patents? Trade secret protection may be unfeasible. So most of the courts of the world have looked at the idea of, once you put something out on the marketplace, if somebody can go in and reverse engineer what you've done, then they could actually use that technology. So if the product that you're going to put out there, you want to cover in trade secret, but somebody could go out there and quickly reverse engineer it, you may want to just disclose what you've done and cover it off by patent, which would then prevent people from actually using your technology. Exploitation, a patent is clearly identifiable asset that may be sold or licensed. Just like real property, you can sell it, you can license it, you can move it around. It's an asset of the business, which can be very important for a variety of reasons. Trade secret protection is destroyed as soon as another party learns of the trade secret through legitimate means. And nowadays that's getting easier and easier and easier to do. Even if the trade secret is leaked through illegal means, an employee of yours stealing the invention, putting it on a microchip, those little flash drives, those jump drives. You can store a lot of information on those nowadays, and there's a possibility that somebody might take that information and take it to your competitor and give that to them. Although they obtained the information illegally, the trade secret is now out, and it's very difficult in today's day and age with the web and the speed of information transfer to be able to stop the spread of that trade secret getting around. So some mistakes to avoid in terms of the patents and well as trade secrets: avoid public disclosure. Public disclosure before you file a patent application can be deadly to you. In many jurisdictions, such as Europe, which is a very big market for a lot of companies, that will actually destroy any chance you may have to get a valid patent. So be very careful on how you disclose your invention or your innovation to others before you file a patent application. Things you can do to protect yourself: consider confidentiality agreements, and remember that there are grace periods available in certain jurisdictions, and I'll get into that a little bit later, that can save you in certain places if a disclosure has been made. Another area that always causes a lot of problems is ownership. Get confirmed in writing before the invention is created. Even if you pay, the general rule is you don't own. So I always recommend have it in your employment agreement that whatever is created well under the employment of your company is owned by the company. That's the best starting basis, so everybody's on the right page. But as inventions are made and innovation is developed within the company, make sure you have assignments from the inventors to the company. Make sure you own that patent. It can get very messy down the road if you don't. And again, like Stu mentioned, co-ownership could be kind of messy during licensing and litigation, much like Stu was talking about with copyrights. If a patent is co-jointly owned, one party can assign their rights to a potential competitor, and there's not much you can do as a co-owner to stop that. Important point to remember, just because you get a patent doesn't necessarily mean you have freedom to operate. Nowadays, a lot of patents are improvements on already existing technology. Just because you get a patent for that improvement doesn't give you the right to use the underlying technology. You will still have to license that underlying technology in order to work your improvement. But again, when you talk about the value of the patent, that can be used in a negotiation tool with the company that owns the underlying technology to see if the two of you can work together and possibly come up with a way that you both can be successful and generate money. And in the life science world, regulatory approval is often another hurdle that you have to overcome in order to actually practice your invention and your innovation. As I mentioned, some countries, such as Canada and the US, have a grace period. So they allow you to make a disclosure, and then within 12 months of that disclosure, file a patent application. That can be very valuable because often there's disclosures by accident. You know, somebody goes to a conference and discloses what they're doing to a colleague over a couple of beers, and that's actually a public disclosure. That starts your clock ticking. But in Canada and the US, you have 12 months from that time in order to file a patent application. A lot of other countries are moving that way. Brazil and Australia now have that, but certain countries such as Europe, or certain regions such as Europe, do not actually have this provision. They require absolute novelty. So how do you, what's our strategy for filing a patent application? Typically, your first application is filed in the US. People will say, well, why do you do that? The US, I said most countries worldwide operate on a first to file system. The US actually works on a first to invent system. And you have to be able to establish that invention date on US soil. So by filing your patent application in the US, in the first instance, actually establishes that invention date on US soil. So we typically do that unless there's some other reason for filing in Canada or another jurisdiction first. From that first application, we would typically, at the 12-month mark, look at different jurisdictions that might be of interest to you. In this case, Canada, the US, maybe Japan, depending on the technology. Especially if it's high tech, you'd probably be looking to Japan. There's also another system, let's go here, called the PCT system, which again allows you to get that priority application in first. We would file that in the US. But at the 12-month mark, you can file a PCT application, which is, in theory, an international application. It gives you a placeholder in 145 countries worldwide. And it essentially allows you a little bit more time to make that decision in which countries you want to file in down the road. So it's a really nice system that, let's see, so you've got 12 months here before you file the PCT. But then once you file the PCT, you have an additional 18 months before you have to start activating that PCT application in the jurisdictions of interest. So from the time that you've come up with your invention, 30 months later, you would probably have a pretty good understanding of where your markets are going to be and possibly the importance of your technology. And then therefore, you may then file your patent applications in more than just Canada and the US. Again, once you get your patent, you can license it like real, and it can be exclusive, non-exclusive licenses. You can assign your rights to somebody else. And then the last thing, and we always try to avoid this, you could sue other people for infringing your patents. But again, that's very expensive, big time investment. So my 9 tips for cost-effective management of patents: provide the person you're working with a comprehensive invention disclosure. I can't stress enough, a good invention disclosure, just outlining what you've developed, is really, really helpful to the patent agent that's drafting the application for you. Avoid trying to draft the patent application yourself and sending that to the agent, because that actually slows us down quite a bit and ends up costing you more money in the end. So good disclosure, flow diagrams, descriptions of what you're doing helps. Attempts of drafting a patent application don't help. Try to do as much in-house as you can. Do some prior art searching in-house. The databases are readily available and they're pretty good and easy to work with. So figure out what's out there and give that to your patent agent as well. Draft a proper application will save costs downstream. There are people and firms that will draft applications for very, very cheap. Essentially, they'll take your invention disclosure and file it for you. There's a lot of problems with that in terms of whether there's any support for the invention that you claim down the road, whether you disclose too much. In this game, you get what you pay for, so just keep that in mind. Keep clear records of what you're doing, inventorship records and any confidential disclosure agreements that you may have. Keep those all close at hand. File strategically. We'd all want protection all over the world, but at the end of the day, that's too expensive. I get this question all the time, what about India and China? Well, they're very expensive and enforcement is sometimes an issue in those two countries. So what I often recommend is, well, where are your markets? Let's try to protect ourselves in your markets, and that way if somebody does actually make your product in China or India, they can't sell it anywhere because we're going to have blockers up in Europe and Canada, the US, etc. Prosecute wisely. Again, it's a little bit more costly to get things through quickly, but then might be savings down the road. Evaluate your portfolio regularly. At the end of the day, you don't want a patent that doesn't cover what you're doing, and that can happen. Determine FTO early, so that's freedom to operate. Determine whether, at the end of the day, you can actually work your invention or you're going to need a whole bunch of licenses in from other people to have the underlying technology. And then good communication with your patent agent. That's key. Let them know what's going on. Let them help you evaluate when patent applications should be filed.